And hello, everyone. Welcome to the 7th event organized by the Space Arbitration Association. So we are already in October, and soon this event series will end. We have 2 more events in November and December, and soon we will inform you about what's going to happen with the Space Arbitration Association next, because we are looking to expand the management structure of the association and to add new activities next year. So if you follow us on LinkedIn, you will be informed soon. And before we start, thank you to Thorsten and to Spacewatch Global, and now to Elena, who has replaced Chiara, for hosting our events. I'm very, very, very grateful for their support, because without Thorsten and him believing in this idea from the beginning, I think none of this would have been possible. So with this, we will start with today's topic. And today's question is whether space arbitration fits into the new space economy. So in the last month, we have addressed several more academic angles regarding dispute resolution in the space economy. And today we will focus a bit more on the industry perspective and shed light on different sectors that constitute the space economy. So we have with us today Melo from the Brazilian Space Agency, who will describe current space activities in Brazil and the role space arbitration can play in them. Rolf Olofsson from Space Law Advisors, who will focus on satellite procurement. Lucien Rapp from Watson, Farley and Williams, who will discuss the use and leasing of frequency spectrum. And finally, Viva Dadwal from King & Spalding, who will talk about her often quoted study on arbitration in the space industry and maybe possible improvements. So as always, I will introduce each of the speakers throughout the conference in more detail. And we will start with our first speaker, Melo, who is joining us from the Brazilian Space Agency. And interestingly, Michele is not a lawyer, but instead she has a PhD in economy with a focus on innovation and industry analysis. She has been a science and technology analyst in the Brazilian Space Agency since 2016, and she's a member of the Space Transportation Committee, the Space Economy Committee, and the Space Entrepreneurship and Investment Committee of the International Astronautical Federation. She is also a professor at the Catholic University of Brasilia and an associated researcher at the University of Brasilia. So as I mentioned, Michele will tell us a bit about space in Brazil. So Michele, the floor is yours. Thank you.
Thank you. Thank you. Thank you. I will share my presentation, just a minute. It's okay? Are you seeing?
Okay. Yes.
Okay. Let's start. Thank you for the invitation. It's a pleasure to be here with you today. It's my first time in talking about arbitration and space economy, and I'm sure that I will learn a lot today, and I hope that I can bring some contributions, a few contributions for this discussion. First of all, we need to understand what is new space. We are listening a lot about this expression, new space, but it's very hard to find an easy definition on it. We can understand new space as a new way to make space activities. A revolution, yes, but why? Because private sector is creating new market and new service. This could include the new service offered through applications of space data or more futuristic opportunities such as space tourism or asteroid mining. We can think about the successful entrepreneurs from other sectors, from Richard Branson in the UK to Elon Musk in the US, have entered the space arena, taking risks and challenging the conservatisms of the established old space business model. And we need to understand old space have as traditional space. And the commercial paradigm shift represents both an opportunity and a risk for government decision makers. The ability of the commercial sector to act as an accelerator and force multiplier of government investments. However, commercial for-profit services do not always align with government needs, and sometimes it's a big problem. And here we can see the impact of the private sector in space. The impact of the entry of SpaceX, for example, in the launch sector was huge. Launching costs for low Earth orbits still have remained fixed in the range of $10,000 to $20,000 per kilogram. And the arrival of SpaceX changed that dynamic. The cost of SpaceX is below $10,000 and it's changing the market. Access to space today is like a commodity. And here we can see the impact of the private sector on space with the new areas that companies are investing a lot of money in the last years. The impact of the entry sorry. So we can see a lot of opportunities here, and the globalization and digitalization of the economy is forcing the creation of new services, and it's basically using space technologies. Satellites are even more necessary, and it's create a little problem because we have a limited position for geostationary satellites, for example. And in the near future, we are going to have another problem, the space debris, because we have a lot of satellites in space. And here we have a space for our legal friends here. Uh, they they can help us to answer a few questions. How can we charge the responsible for the satellites in orbit? Is it possible to establish mechanisms to prevent space debris? What are we doing today to deal with space debris? Who will pay the costs of space debris? So we have a very big arena to arbitration, to space arbitration, and I think that space will increase a lot in the future. But what is the role of the government in this new space area? Because we have a big impact of the new space, and this impact is more about how the government is dealing with the new challenge. Private sector is acting like always, but the government was called to rethink our way to do projects in space. And this is the main point in this revolution. This is the main point when we are talking about new space. So here we can see the example of NASA. It's very important to note how the role will change over the time. In the beginning, NASA had a main role in the projects. NASA was responsible to define what and how to do projects. NASA was the prime contractor. NASA had the full control over the projects, over all the projects. And the role of the private sector is very simple. It's just to execute the project. No, just the execute in the way that NASA told there. And now, with the merging of new space, the function of the government completely changed. And the government needs to fit in this new era. The private sector has their responsibility increasing. And the government now just define the what to do. And the private sector is free to define how to do. Sharing, including the cost of the project. In the beginning, NASA incurs total costs. And now we have private companies investing a lot of the money. For example, here we can see some projects conducted by NASA recently, like commercial orbit transportation service, commercial resupply service, commercial crew development, commercial crew integrate capability, and we have companies like Orbital, SpaceX, Blue Orange, Boeing in Nevada, Sierra Nevada, and other companies entering in the space. NASA now just defines the main requirements of the project, and these companies are free to develop solutions for the problem. It's a big change, and we know that private sector is it's very different from government side. They are more reliable and do the projects and execute the projects faster than government and more cheaper than government too. But talking about regulations, Brazilian Space Agency start a project with Federal Aviation Administration, FAA, and FAA is responsible in the US for the space regulations. And this project between Brazil and the FAA is to create a standard for the launching regulations. What it means that the regulations for launch authorization in Brazil follow the regulations in the US. Why? Why we are doing that? Because we are very interested that private companies that apply in the US could use their license in Brazil too. We are very interested in make this process faster than ever. We really understand that this pattern will be followed for many countries in the near future. And like in the same way that the aviation area, and we think that this could help to create a more reliable, competitive, and clear environment for launching sector in the world. And about arbitration mechanism, in areas when we have an appropriate regulatory framework in operation and largely followed by all stakeholders, for example, in the satellite communication sector, the the challenge becomes to stay abreast of technology progress and market evolution. Together with this challenge, there is an opportunity to develop new regulations that spur further technological progress. Uh, a regulatory framework needs to protect the stakeholders, needs to protect cultural interests, and needs to protect the current and future human rights on one side, but also needs to protect the freedom to develop and exploit new technology on the other hand. And I was thinking about ITU, and our colleague here will talk about the experience of ITU. Maybe one institution like ITU in the space could help to create a standard for regulations and space activities. Maybe regulating space exploration. This ITU for space could be where disputes could be negotiated between countries or between companies. And talking about space exploration, it's a main point because how are we going to discuss the benefits from space exploration? Imagine, for example, space mining. If one company brings to Earth space oils, how are we going to regulate this? It could have a huge impact on the Earth markets. And when we get to Mars, how we deal with the new markets and services necessary to explore it. Consider the outer space street, the space is for all, but it's really true. The first companies to access Moon and Mars are going to share the benefits. How are they share the benefits? Or will they act like owners of the Moon, of the Mars? How are we dealing with these questions? I do not have an answer for that. But I think that maybe Yunus could be a space to do these discussions, to apply the arbitration mechanisms, or maybe we need to create a new arena, something like ITU maybe. Um, and we have a few more questions that remain, and it's very necessary to discuss. It's necessary to renew the outer space treaty, for example. A large number of countries has been done their space acts. How are they treating the commercial activities in this space law? Are, are the space acts respecting the outer space treaty? So I have more questions than answers, and I think that the work of our colleagues here from the legal area will be necessary in the next years, and we need to discuss this right now because the private sector is increasing very fast. So we need to define the regulatory framework for these activities right now. So it's that I want to share with you. Here we have the website from Brazilian Space Agents and my emails if you want to change ideas and discuss a little more. So thank you for the invitation, and I'm ready for the questions if you have one.
Thank you, Michele. So you mentioned that a lot of countries are updating or creating new space laws. So which impact do you think would that have on the space economy the way it is now?
Oh, yes, yes. It's a very, very good question. In fact, we have a lot of companies entering in the space sector and creating their space acts because the only general law that we have is the Outer Space Treaty, and it was created in the 60s. So the countries are running to create a modern laws with mechanisms that allow private commercial operations and the exploration of new services and products. And we have no article in the Outer Space Treaty that discuss this. So we need to think about, are these space acts aligned with the Outer Space Treaty? We don't know. And I think that the Space Act is very different from Outer Space Treaty. Um, it is possible that a Space Act of a country allow a type of activity that another country doesn't. So what can we do? We have a very interesting and complex arena here to coordinate the interest of countries and companies. So my friends from legal area, we are going to need you in the future for sure.
Yeah, it's an exciting time for international lawyers.
Yes.
And one other question, based on your understanding and your view of the space activities you are seeing, in which areas do you think there will be arbitration disputes in the years to come?
Space debris for sure, because we have a lot of satellites in LEO, and we are going to have problems for sure. Space tourism could be an area with a few discussions about private insurance for space travelers. And of course, the discussion about the results of space exploration, like for example, space mining. So how will works the space exploration? A company will be owner of space of Moon, of space of Mars. So we need to discuss this to create a regulatory framework so the private companies could follow in the next years.
Thank you very much. And before we go to our next speaker, I just wanted to say that it's very interesting because Mexico and Brazil have more or less similar economies in terms of their size, and they could have similar positions in the space economy, but Brazil has really developed its space economy and Mexico has not. And this is being written about a lot in Mexico. So it's interesting to compare the two countries, just as another remark. So with this, thank you, Michele. We will turn to our next speaker, Rolf Olofsson, who will talk to us about the satellite procurement sector. And for all of us in private practice, his career is something we can only aspire to. I was very impressed when I saw his background. So I will just tell you the key points. So Rolf Olofsson currently runs the satellite practice at Space Law Advisors in Washington, D.C. He is a Swedish lawyer by training and started practicing law at Mannheimer Swartling in Stockholm, where he became a partner in 1980. In 1988, he opened the firm's first foreign office in New York City. And then he returned to Stockholm and joined White & Case and went on to become global head of communications and media at White & Case. And in 2004, he moved his practice to the Brussels office of White & Case and remained there until 2012, when he came back to DC, again to support the global communication and media practice. And well, now he is at Space Law Advisors. His practice concentrates on general corporate representation and international arbitration involving space and satellites, where he counsels government agencies and commercial enterprises in space-related ventures, including treaty negotiations, mergers and acquisitions, satellite procurement, satellite launches, launch risk and in-orbit insurance contracts and R&D contracts. So Rolf, thank you very much. We're honored to have you here, and we're looking forward to hearing from you. Thank you.
Well, thank you for inviting me. And I will sort of start by answering the question, does space arbitration fit into the new space economy? Well, my answer is a resounding yes. Now the question is, what is the basis for my conclusion? Well, before I go there, just a bit of my background. I've spent altogether about 25 years practicing in Sweden. As you heard, I'm a Swedish lawyer, 8 years in Brussels, and by now 16 years in the US. I mentioned that this merely to indicate that over the years, I've been exposed to at least 3 different legal systems, although I've only given advice, legal advice with respect to one of them, I should point out. Now, dispute resolution in Sweden is one reason why I'm here, I think. Sweden has a long tradition of resolving business dispute through arbitration, going back to close to 100 years. Accordingly, you will find very few cases of any significance related to business disputes that have been adjudicated in the courts, and fewer still that have resulted in judgment issued by the Swedish Supreme Court. Arbitral tribunals in Sweden have for a long time, for the most part, consisted of lawyers, including judges from all levels of the court system. For very important cases, tribunals have often included a justice from the Swedish Supreme Court. Generally speaking, arbitral awards in Sweden are reasoned legal determinations of the case, and given the quality of the lawyers on the tribunal, mostly resulting from proper legal reasoning, except when I lost the case, sorry. This has, to my knowledge, always been the case, as opposed to here in the US, where in the early days of arbitration under the AAA rules, the judgments were more of a compromise, possibly because the arbitrators in those days were often not lawyers, but rather businessmen. I understand that AAA has since taken steps to address this issue. The Swedish approach to dispute resolution and the fact that Sweden during the previous Cold War was a neutral country led to an agreement between the US Chamber of Commerce and the Soviet Department of Trade, which provided that disputes between US companies and Soviet government entities could be resolved through arbitration in Sweden. And those awards would be recognized in the respective countries. This model was subsequently adopted throughout the Soviet bloc and also in China. This in turn has resulted in Stockholm becoming an important international hub for arbitration. Resulting from the significance of arbitration, it's standard for any business agreement in Sweden of any significance, whether purely domestic or international, to include an arbitration clause. Given the nature of my practice, I have over the years served as counsel or arbitrator in Swedish domestic, commercial, and construction disputes and international arbitrations under the Swedish Arbitration Act, the UNCITRAL rules, ICC arbitration rules, SEC arbitration rules, and AAA arbitration rules. Now, my engagement in the space industry, as Laura indicated, started in 1980 when I advised on the procurement of a scientific satellite. The satellite was appropriately called Viking, as it was a Swedish satellite. In fact, it was the first Swedish satellite. Viking was ultimately launched in 1986. It was launched as a piggyback arrangement together with a French satellite, the first spot satellite, a remote sensing satellite. The launch was performed by Arianespace from French Guiana on an Ariane rocket. I believe it was Ariane 4. As my client also became engaged in the Spot satellite project and the establishment of the first commercial remote sensing business, I also worked on all of the contractual elements involved in establishing a company for the purpose of running the reception, treatment, and sale of remote sensing data from the Spot satellite, including the treaty between France and Sweden and the implementation agreements between CNES, Spotimage, and Swedish Space Corporation, which was my client. My next satellite project was the procurement of a telecommunication satellite, including significant terrestrial infrastructure called Tele-X. Tele-X was launched in 1989 and placed in geostationary orbit at 5 degrees east longitude, from where it provided fixed satellite services to Northern Europe with a primary focus on Scandinavia. Tele-X was a high-power satellite, provided signals with an EIRP of 65 dB watt, which anyone who has technical knowledge understands that allows for very small terminals, less than 20 inches in diameter, to receive the signal. The project included treaty negotiations between Norway, Finland, and Sweden. The negotiations ultimately resulted in an agreement between Norway and Sweden to jointly pursue the Tele-X project with the engagement of the Norwegian and Swedish telecoms. If you wonder why the telecoms were involved, well, at that time, we still had national telecom monopolies in Europe. So the engagement of national telecoms was considered the only way to offer services to the public from the Tele-X satellite. By the time Tele-X was finally launched, the legal environment had begun to change and telecom monopolies were on their way out. From the 1990s and onwards, my engagement in the satellite industry has continued to include negotiations and drafting of satellite procurement contracts, launch service agreements, launch and in-orbit insurance agreements, financing agreements, and various satellite managed services agreements, and any legal or contractual issues that satellite operators, satellite manufacturers, or financing partners face from time to time. But over time, I've also had reason to advise clients and manage disputes in the satellite sector. While the disputes, so going on to the advising on disputes in the space sector, while the disputes have all related to the satellite industry, they have arguably, in some ways, been ordinary business disputes, such as disputes regarding late delivery of the satellite or disputes regarding liability for malfunctioning satellites. What makes these disputes special are the damages resulting from these risks. That is, late delivery of a satellite with the resulting loss of a launch opportunity or the malfunctioning of the satellite are so absolute and in most cases may not be easily remedied once they have occurred. By way of example, late delivery of a satellite may result in a missed launch opportunity, which in turn requires procurement of another launch at a significant increased cost and a long delay in delivery, which in turn may lead to the loss of customer contracts that are not easily replaced, resulting in significant losses upon launch of the satellite. Since the capital expenditure required for a GEO communication satellite, including manufacture, launch, and insurance, often amount to $250 million or more, it is essential for the business plan and the financing of the satellite that it delivers the performance contracted for and it arrives timely at its orbital slot. By way of example, in 1995, my client entered into a contract with a satellite manufacturer for the delivery of a satellite named Sirius. It was to be delivered at the launch site within 24 months, which in this case meant June 30, 1997. The time was truly of the essence, as the satellite being procured was needed to replace another satellite, which was at the end of life, with transponders that were due to malfunction at any time after the scheduled delivery time. The satellite manufacturer was late in delivery by more than 4 months. 1 week before the satellite had reached its orbital position and could be brought into use, the satellite that it was due to replace lost one of its transponders, which carried a TV program broadcasting over the Nordic countries, direct to home and cable distribution. The satellite operator could offer another transponder, but not in the same frequency band, which meant that at that time, the TV channel could not automatically reach its viewers. In fact, there would be some time and efforts to again reach those viewers which needed to change the frequency manually at which they received the signal. And this required more work than most viewers were prepared to perform. This resulted in the TV broadcaster terminating a contract with the satellite transponder and moving the services to another satellite operator. My client then charged the satellite manufacturer the maximum amount of liquidated damages for the delay in delivery, which was $10 million. The satellite manufacturer was not ready to accept this and initiated arbitration, attempting to recover all or part of the 10 million. The satellite manufacturer lost the arbitration, was ordered to pay the respondent's costs and legal fees in defending the case. Another arbitration where the result has been published concerned an ICC arbitration brought by the insurers of the Thuraya D1 satellite and Thuraya Satellite Telecommunications Company, which were the claimants against Boeing based upon allegations of gross negligence for the manner in which the Boeing manufacturer of the satellite handled solar array defects on the Boeing Model 702 satellites. The claimants got reimbursement of $219 million paid to Thuraya under the launch risk and in-orbit insurance. Claimants alleged that Boeing was liable for defects in the satellite appearing after launch, which Boeing denied. In the ICC arbitration that followed, Boeing engaged a number of experts on satellite procurement contracts to provide evidence to the arbitral tribunal whether the wording of the contract, which provided that after launch, the satellite manufacturer's liability for defects appearing in the satellite was limited to carrying out those corrections or repairs that could be performed from the ground. The question was whether this represented industry standard. I was part of the group of experts. Upon providing a written opinion, I was selected to give testimony to the arbitral tribunal, which I look forward to doing. I should say, of course, that the group of experts said that this language in the contract represented industry standard. So I was selected to give testimony to the arbitral tribunal, which I look forward to doing. However, the arbitral tribunal decided towards the end of the hearing and the day before my scheduled testimony that there was no need for me to testify. Although I was slightly disappointed at missing the opportunity to testify because there was a very distinguished arbitral tribunal in Paris, I was at the same time pleased at the decision since it made it clear that the arbitral tribunal had accepted Boeing's position with respect to the manufacturer's liability for defects in the satellite appearing after launch. The arbitral award went in favor of Boeing, which was also awarded full compensation for its legal fees and expenses in defending the claim. Now, I've identified some issues specific to disputes regarding space projects, where international arbitration is preferable, if not always essential, in order to have a proper resolution of disputes. For full disclosure, I should say I've liberally used a list appearing in an article written by Raymond Bender. So the first area I would identify is ITAR. For projects with a foreign nexus, one can expect to address US export control issues, and in particular, ITAR, which of course is a special US regulatory regime aimed at controlling the export and transfer of US technology to foreign persons. An international arbitration relating to a contract governed by ITAR adds complexity, but can be conducted successfully with attention to US security concerns and cooperation among arbitrators, parties, counsel, and US government officials. Generally speaking, I've found that almost all satellites that I've had reason to be engaged with have components that are covered by ITAR. While attempts have been made by satellite manufacturers outside the US to construct so-called ITAR-free satellites, Satellites that do not include any US components covered by ITAR are, to my experience, rare. I have not run across one. The reason for this is that the US munitions list, in spite of its name, is very extensive and covers many items which do not have a military application. Through the use of so-called technical assistance agreements, TAAs, and filings with the Department of Defense or Department of Commerce, depending upon the technical issues, requiring the parties can conduct and resolve the dispute through arbitration. This would not necessarily be possible if the parties had chosen to resolve their disputes in a court of law in a country where one of the parties reside.
Rolf, apologies to interrupt. If you could summarize your remaining points.
Yes. Yes, I would say then that
thank you.
The other area that where international arbitration it allows for the procedural rules to be more flexible and adjusted to the dispute at hand. Also, it allows for selection of arbitrators that have knowledge in the area or can be capable of understanding the technical issues. Further, it allows for confidentiality of the dispute and including the award. The discovery, and it also allows, when you have different jurisdictions, for US companies, are used to discovery. Companies outside the US are not used to that and may not favor that. And you can strike a compromise, which several arbitral institutions have in their rules, where you have a limited amount of discovery, but not the overburdening one that they have in the US. And finally, enforceability, perhaps the most important one, that arbitral awards, are enforceable because most countries are members of the 1958 New York Convention. That covers my.
Thank you very much. I think the main advantage is that parties in arbitration can select arbitrators like you to benefit from this extensive experience in the industry. And based on your experience, which areas of the legal regulation of the space industry do you think need improvements?
I would say perhaps, I'd say the areas concerning space debris.
Debris.
Yeah, I mean, the number of satellites have grown from a few hundred to over 2,500. At the same time, objects down to 2 centimeters that have been tracked have, grown from due to collisions between, say, Iridium and Cosmos, for instance, and also due to, unfortunately, intentional destruction of satellites by China testing a missile that intentionally destroyed the satellite. Similarly, and that created 3,300 fragments. Russia performed another ASAT, creating over 1,000 fragments. And there are currently no international requirement to remove objects from orbit, and no legal foundation for a country that is not a state of registry to remove an object from orbit. So this has, for instance, led to space station having to perform dozens of evasive maneuvers due to collision risk, and the crew to seek shelter in crew capsules. There is another estimate that I just read about, where there are expected to be 8,000 metric tons of dead objects in orbit and 900,000 individual pieces of debris that can be lethal to satellites. This is obviously an area where we need a treaty covering both the responsibility for removal of space objects, currently on orbit and mechanism that will limit the growth of this number. So I think that to me is the most important issue at hand.
Yeah, so Michele and you seem to agree on that. It's said that this is probably one of the areas where it will be difficult to have arbitrations because there's no contractual basis, but we can see if we can solve this somehow. Yeah. Thank you very much, Rolf. And with this, we will turn to another potential arbitrator for space disputes, Lucien Rapp, who is also very experienced. He is a professor at the University of Toulouse Capitole in France, where he heads the Serious Chair, a corporate chair dedicated to the law and economics of space activities. He's also a lawyer at the Paris Bar and a legal consultant at Watson, Farley & Williams in Paris. He has participated in the elaboration of French national texts related to space activities and has been advising major operators and governments in the space field for many years, in particular on regulatory or contractual aspects of space activities and related litigation. Thank you, Lucien, for being here with us, and the floor is yours.
Thank you, dear Laura, for kindly inviting me, and congratulations for the great work which is done within the association, the Space Arbitration Association. You are doing a lot, and you must be congratulated a lot in this regard. I'm going to share a screen in order to allow you to follow me. And that's it. I only have been granted about 10 minutes, and I would like to spend them on a case. This case will take us to the crossroad of international regulation, national legislation, and contractual provisions. We will obviously talk about international arbitration. However, I would like to specify that, to my knowledge, the case that I am going to consider has not given rise to international arbitration to date. Before doing so, I would like to return to the evolution of the radio frequency regime. This slide focuses on the way in which the rights to use the frequency spectrum have become object of commerce. After the Second World War, in Europe at least, governments agreed to give the frequency spectrum a status distinct from that of airspace. However, it was not until the end of the 80s that the legal regime of the spectrum was determined, and the very beginning of this century that it was considered that the right to use the spectrum were assignable and transferable. From then on, everything moved very quickly, since at the end of the first decade of this century, the first national decisions authorizing companies to capitalize their frequency rights on their balance sheet were issued. And then, in the middle of the second decade, the first commercial agreements between operators on ITU filings were concluded. The current decade will perhaps see the development of arbitration disputes around frequencies. You all know the ITU, which was mentioned by Michele a few minutes ago. You know the ITU with its management, the Radio Communication Regulation Bureau, and the 7 study groups, among which the study group number 4, which deals with satellites. You all know the World Conference, which meets every 4 years, and the ITU radio regulation, which has the value of an international treaty. You all know that radio frequencies undergo 3 successive operations: an allocation between different uses, then an allotment to mobile services, for instance, and finally, the assignment to operators. I mentioned ITU filing. These are frequency reservations, particularly for satellite services. These reservations are made by national administrations upon the request of operators. These reservations are registered by the ITU on a chronological basis. To avoid frequencies being frozen for too long, as was the case during the Cold War, a date of commissioning named bringing into use is declared by the administration, which notifies the ITU. The deadline of bringing into use of the satellite system cannot exceed the maximum duration of 7 years, with the possibility of a suspension of this duration during a period which can go from 6 months to 3 years. At the end of this period, if the bringing into use of the satellite has not been notified, the frequencies are released. The case I would like to introduce concerns the trade of these ITU filings, which is expected to grow in the years to come, mainly due to the scarcity of available frequencies. Let's take the example of a satellite operator who wants to buy a satellite from a manufacturer. Let's then imagine two different situations. The satellite operator has been able to submit an ITU filing through its national administration, or the manufacturer can hold an ITU filing which he agrees to grant to his customer. The agreement between the customer and the manufacturer, whatever its scope, includes an arbitration clause. These ITU filings, the one of the customer or the one of the manufacturer, foresee a deadline of commissioning, bringing into use, as we mentioned before, at the expiration of which the frequencies are to be released. Let's imagine now that as the deadline for commissioning approaches, the manufacturer cannot deliver the satellite ordered by the customer. Then the manufacturer or its client will seek to approach another company who would have either filled an ITU filing with the help of his national administration and whose commissioning date is still far away, or who already holds an operating license issued following a previous filing and the commissioning of the satellite within the deadline. This second agreement may include an arbitration clause. Without wishing to complicate the scheme, it could happen that the manufacturer's customer is also contractually bound to a third party, a bank, for example, and has provided its operating license for guarantees, which may make this third party the ultimate beneficiary of the above transaction. The agreement between the third party and the client may in turn include an arbitration clause. Now, let's go back to additional elements of the problem. Here is an example of the procedure followed in France by any operator wishing to reserve frequencies with the ITU. The operator applies to the ANFR, an organization whose mission is to manage the frequency spectrum in order to optimize its use. The Agence Nationale des Fréquences Radioélectriques, ANFR, then declares the file to the ITU. The ANFR is therefore the notifying administration for French operators. Once this declaration is made, the French Ministry of Economy is in charge of authorizing the applicant to operate this frequency. This authorization decision is issued after the ANFR has reviewed the application and issued an opinion. Usually, this opinion is preceded by a public consultation procedure, which allows any third party to make its comment. The operating license is granted for a period of 20 years. On the right hand of this slide, I have included 3 hypotheses retained by French law in which the operating license can be either lapsed, amended, or withdrawn. This further complicates the situation and leads to potential arbitration dispute. An interesting point for the lawyer, and one that can give rise to litigation, is the question of the status of this ITU filing. As previously noted, the initial application to the ITU is filled by a notifying administration. Let me remind you that the ITU is an interstate organization which only knows states and governments as well as their national administrations. The use of frequencies declared and then authorized by the state is the privilege of an operator, who is in principle the one who pushed the notifying administration to submit a filing to the ITU. The operator, with the beneficiary of the authorization, the operating license, can in turn transfer its frequency right. Thus, from a strict legal standpoint, we have 3 operations: the initial filing to the ITU, the operating license, the transfer of its use to a third party. Consequently, there are 3 participants in the commercial transaction: the notifying administration, the beneficiary of the operating license, and the assignee of the right of use granted by the operating license. And this assignee could be either an intermediate holder of the operating license or final holder. This throws confusion on the nature of the filing and especially on its ownership. With the owner of a filing, the notifying administration that applied for it initially, or the beneficiary operator of this ITU filing, or its assignee, which happens in the event of a withdrawal of an operating license when the beneficiary operator has transferred his right of use in advance. How should be settled the consequences of a bankruptcy filing by the beneficiary operator who has transferred his right, or a bankruptcy filing by its assignee? Should we treat the right of use as assets that fall within the scope of a judicial liquidation? How should we deal with the delicate hypothesis of the acquisition or the takeover of the beneficiary operator or its assignee? All this reminds me personally of the debates that arose over airport slots a few years ago and which gave rise to interesting arbitration cases. Then this is what justifies the interest that I think any lawyer or arbitrator should have in these operations, the main elements of which are summarized in my last slide, along with an indication of some of the issues that arbitrators may have to discuss. Let's take a look on them. Discussion on the qualification of the bringing into use delay as a force majeure case, administrative blockage, in relation with the refusal to issue an authorization or a delay in issuing an authorization, negligence of one of the party in fulfilling a formality, casual default of the satellite operator, lapse or withdrawal of authorization. Thank you for your kind attention. I am more than ready to answer your question, if any.
Thank you, Lucien. This is fascinating, and I think something that many people might not be very familiar with. And just to maybe have a better idea of what we are talking about, what is the financial stake of an ITU filing? Like, which amounts are we talking about in these kind of cases?
Yeah, actually, there is no market price. And these transactions are usually very confidential. Some transactions are done at very high prices. We are talking about millions and even 10 millions of US dollars or euros. And a few international consulting firms have positioned themselves on what could be a real market for the valuation of this type of transaction. And in the event of an international litigation, the market for valuation of the damages suffered.
Thank you. And if for example, for the lawyers amongst us who might need to advise on drafting arbitration clauses for these kind of disputes, which national law would you recommend to include in an arbitration clause?
I would recommend, since these are very technical disputes, I would recommend the law of countries in which we have, for example, space law. We heard about the Brazilian law. I can, of course, elaborate on the French law. And basically, these laws, or these national legislations, which ground up along and increase a lot along the past years, are good references for any parties to a contractual agreement, to a transaction in which an arbitration clause is provided for. And I'm quite sure that in this national legislation, you will have generally the three coaches of regulation. I mean, the coach of law, then the regulation itself, the decree, the ordinance, and at the end of this hierarchy, you will find all the technical regulation which are often really needed in this kind of dispute.
Thank you very much. And I'm taking advantage of your great presentation to advertise our next event, which will deal exclusively with frequencies in the ITU and focus on coordination disputes between different operators. So if you're interested in these topics, don't miss the November event. So thank you, Lucien. And we will now turn to our last speaker for today, Viva Dadwal, who has become a good friend of mine through our space discussions, even before we launched the association. And she is actually one of the few lawyers who in recent years has written about arbitration and space. And she did a study which is quoted in almost all of the articles that are now talking about arbitration and space. So we are looking forward to hearing from her about how she did it and what the conclusions were. But first I'm going to introduce her. So Viva is an associate at King & Spalding in New York and a member of the international arbitration practice there. Her practice focuses on commercial and investment treaty arbitration and on enforcement proceedings before US courts. She co-leads the research project on space-related disputes at McGill University Institute of Air and Space Law, which focuses on identifying and promoting dispute resolution mechanisms to facilitate the peaceful resolution of outer space disputes. Viva previously worked for the Government of Canada, assisting with international trade and investment treaty negotiations. Thank you, Viva.
Thank you for having me. I'm just going to share my screen as well and make sure that everyone can see it. Please let me know if you can't.
Oh, we can.
Okay, excellent. So thank you, Laura. Thank you to the Space Arbitration Association, and thank you, Space Watch Global, for having me. It's a pleasure to be amongst such interesting panelists. And my presentation will be a little bit more high level. We've heard about some of the types of disputes and some of the types of activities that are in space. So obviously, it should not come as any surprise that the space economy, like any other sector, needs a forum where participants can go to resolve their disputes. The first place I think of when I think about disputes is courts, just because they're everywhere. They're in every country. And here in the U.S., some of the space activities, certainly the companies are federally regulated, and they end up in federal courts. So on this slide, you'll just see two examples of disputes involving new space companies. These are large companies. On the left is SpaceX, on the right is Blue Origin, bringing their disputes in US courts. And the reason why I'm sharing this slide is just mostly to make the point about how the new space economy has grown. So on the left is a news article from 2005 when SpaceX filed a suit in federal court in California, charging that the creation of the United Launch Alliance, which was a joint venture between Boeing and Lockheed, was anti-competitive. So it was trying to get into the launch market, and it was filing a suit to try to get in. And I think Michele talked a little bit about the price of launches and how they've come down. And on the right, fast forward 15 years later, Blue Origin was suing NASA, alleging that the agency unfairly awarded the contracts for the first 2 moon missions to SpaceX. So I thought this was just a fun way to show how some of the new space companies, right, and what we mean by that is also not the usual suspects in space, which used to be states, have grown, and how they've taken up this sector. So obviously courts are not the only place where disputes are resolved. They're one forum. I think they're an important forum. I don't think they're going away, but they're not, it's not the only forum. And so there are other ways of resolving disputes that complement litigation in courts. And so we were interested, this was a few years ago, we were interested in just learning about where these disputes were going to be resolved. And so we launched an anonymous survey to assess the needs and preferences of those who were in the space industry, and so legal counsel, advisors, and so on. And we found that a majority of the respondents in the space sector valued confidentiality, they valued technical expertise, we've talked about this a little bit today, and they valued timeliness. But we also found that a majority of survey respondents in 2019 thought that arbitration was going to increase in the future. And so given that I work in the field of arbitration, it was interesting to me to look further into it. And so we followed up on those insights in 2020, just by going out and researching publicly reported space-related arbitrations. We found about 40 of them, and we wanted to, deep dive into those and see, whether there was data, whether arbitration was actually being used. At the time, there were also conversations about other ways of resolving space disputes. So it was almost a test to see to see whether or not arbitration was a suitable way of resolving space-related disputes. So as you can see on this slide, we were able to find, well, in fact, that there was an increase. And part of it is because, not all arbitrations, I think they've been happening for a long time, but they might not be reported. We have, people on this panel who've probably worked on several arbitrations, but it also comes down to the reporting. But regardless, we found that arbitrations were going up especially between commercial parties, which is also to be expected in a new space economy. And they were going up in the satellite sector in particular. They had been in the satellite sector. It's more of a mature industry compared to kind of some of the other applications that we'll see. And I think this is also confirmed by some of the panelists today. So we observed disputes over the launch and delivery of satellites, over regulatory measures, over leases of satellite capacity, insurance disputes, technical failures in space, manufacturing, sale, and purchase. So these are the types of disputes we were seeing. And then the next, kind of interesting point from a practical perspective for me was where, if you're not going to court, where are these commercial parties often going to resolve their disputes? And we found that the results actually confirmed what we had seen in 2019 when we surveyed the participants in the industry, like when we surveyed the actual people, that the ICC, the ICDR, the LCI, so the International Court of Arbitration, the International Center for Dispute Resolution, and the London Court of International Arbitration were some of the most used arbitral institutions. That doesn't mean these, there weren't other ones, obviously there were other ones, but these were, at least from the survey that we had, the most used. And it was nice to confirm that with our survey of the publicly reported cases themselves. So I'll now just give you a taste of, and I think we've already gotten a lot of deep dives into this field, but here's a flavor of how arbitration might play out in practice in commercial and investor state arbitration, which are the two main forms. State to state is also there, but I'm not aware of any state to state arbitrations personally. So the first example here is commercial arbitration reported between Eutelsat, which is a French company, and SES, which is a Luxembourg-based company, which involved the use of frequency spectrum. And we heard a little bit about this from Lucien. We also heard about it from Rolf. So I won't focus too much on it. I think of orbital slots as like parking spots. So that's my way of dumbing down some of the technical information. So Eutelsat had a parking spot in a particular location, 28.5 degrees east, and was trying to beam television and radio signals to a particular part of the Earth. And SES wanted to use the same parking spot. And so the two parties were disputing whether or not they could use particular frequencies from that parking spot. Basically, the question was about, whether or not Eutelsat could be there. So the dispute was brought under the ICC rules. We had a distinguished panel of arbitrators, and the first phase of the arbitration, there was actually a decision where the tribunal found that, well, yes, SES could use that parking spot so long as Eutelsat did not hold the regulatory right to be in the same spot. So I won't go into the technical details. And in fact, the arbitral tribunal didn't get to go into the technical details either. We didn't end up learning about whether or not Eutelsat could be there because there was also a court case happening at the same time where a decision had been rendered and the parties ultimately decided to settle the dispute. So here you can kind of see the interaction between arbitration and courts, and arbitration playing a role in helping the parties in actually, ultimately settle the dispute. So this was just one example that I wanted to share from on a commercial level. The second example has actually been talked about a lot. It's quite a controversial case. I won't go into the details because there are a lot of details here, but also involved frequency allocation, involved both commercial elements as well as investor state elements. So investor state arbitration. There was an agreement between Davis and Antrix, where Antrix, which is an Indian state-owned entity, had leased a portion of India's S-band frequency to Davis. It had also promised to build and launch satellites for Davis, but ultimately this transaction fell through because there was pressure to cancel that agreement between the Indian state-owned entity and Davis, which was a company that was foreign owned as well. So when that agreement was canceled and India has cited national security reasons after the fallout, there were several arbitrations that came about, not only commercial but also investor state, that amounted, the damages claimed were above, $1 billion. So we have an ICC case. There was a case between Davis and India, where it's Davis, the company, sued India in particular. And then also Deutsche Telekom initiated another, which was an investor in Davis, initiated another arbitration against India under a different treaty. So this is another example where arbitration was used. I won't, again, another claim was filed in February 2022. It's quite a controversial example just because there have been set-aside proceedings and there have been allegations, of fraud in the actual in the ICC arbitration. Not allegation, actually, the Delhi High Court actually set aside the award. So this is a complicated case, but this is an example where you can see that arbitration is not only being used between commercial parties, but also between commercial parties and states, right? So countries for disputes that you can't always bring in court. So having given you just some of these data points, I would like to just conclude by saying that I do think arbitration plays an important role in the new space economy, which is what the title of this panel, or what this panel seeks to answer. I think arbitration plays a key role because it provides a reliable way of resolving disputes, which I think is important in the development of international space law. And I think that is important for any economy, not only the space sector. The reason why I think it's a reliable tool is because new space, as we see it, it's an economy that involves a global industry. It's in the past 10 years, there's been a lot of private investment in the sector. There have been new actors, big and small, new cultures, new countries, different expectations, right? So it's no longer the old kind of Cold War era type industry. It is an international industry. It's a competitive industry. It's a technical industry. And so parties actually do need to find a common way, a neutral way of resolving the disputes when they arise. And so I think arbitration provides that international legal infrastructure, to my knowledge, to the, out of the other ways of resolving disputes, this is the best one that I've seen in the toolbox. There's flexibility, and I think we heard about this from our panelists. There's finality, there's the ability to enforce the awards. And I think arbitral institutions in particular, which is what this slide is about, play an important role in helping resolve these disputes. So what is on the screen here is a little bit about the Permanent Court of Arbitration Outer Space Rules. The PCA is an intergovernmental organization. It involves 122 states. And in 2011, they launched these rules. Now, the rules haven't been used, and I'd be curious to our panelists' thoughts on why, but the rules themselves actually do meet the demands, which is what I talked about earlier when I started the presentation, of our survey respondents who talk about confidentiality, about timeliness, about technical expertise as being important in their dispute resolution process. And a model clause is found in the annex of these rules themselves, so you can copy paste it into a contract. So I think I'll end with that. I think, the answer, whether, space arbitration fits into the new space economy, the answer is obviously yes. And I think it actively contributes to the growth of the space economy by providing a reliable way of resolving disputes as well.
Thank you very much, Viva. So we've heard a lot about the advantages of arbitration for space disputes. But maybe before we end for today, could you tell us a little bit about the limits of international arbitration, maybe for the space industry or in general? And I think this also could answer one of the questions I saw in the Q&A session, which asks how we can combine or close the gap between the role of public courts and public regulation and private international arbitration. Thank you.
Yeah, so I think arbitration is just one of the tools that, one of the ways, and that's why I also wanted to make sure I highlighted courts. It's not the only way. It's one of the ways. I think it's not appropriate in all dispute resolution scenarios. And we heard a little bit. I think Michele, you had offered some thoughts on where disputes might arise. They might arise in the space tourism sector. They might arise. I think Rolf also talked about space debris. So we expect disputes to arise, and the question is whether arbitration can be used for all those types of, the types of disputes that arise and the disputing parties. So in my view, I think consumer disputes or environmental disputes are harder to resolve through arbitration. I think, Laura, you talked about the fact that, for example, space debris, right? Unless there's like a way to connect kind of the law with the way in which you're going to resolve the dispute, unless there's some tether between the two, you can't just start an arbitration. It's hard to do that. And so I think with environmental disputes, or even, when we talk about consumer disputes, which is, another area where, for most consumer disputes, America is a bit different. There are reasons why, for the public good, we don't necessarily use arbitration. That doesn't mean it doesn't happen. It's a choice as to when we want to use arbitration as a tool. The other, I think, limitation on arbitration is cost, and arbitrations can cost a lot. So I think when we talk about the new space economy and some of the actors that have sprung up, of course, I'm not talking about the SpaceX's and the Blue Origins of the world anymore. I'm talking about some of the smaller enterprises that come from other cultures, that might actually be smaller companies that actually have a lot, they're working on a different model. The cost of arbitration might be too much. Now, of course, there's third-party funding, which is something that, everyone in arbitration is familiar with, but I think cost is another kind of limitation to using arbitration. And I think the third one is just culture, which, like I said, arbitration is not, it's an adversarial system. And that doesn't jive with everyone. It's not the way, certainly when you want to preserve relationships, it might not be the best way to do that. Now, of course, there's nothing stopping you from settling the dispute. But, I think there are, again, other tools in that toolbox. And I'll give a plug to kind of the Singapore Convention and mediation, which has recently, come about, which now offers an opportunity to actually enforce mediated settlements. So I think there are other ways in resolving disputes. I don't think arbitration is the only one. It has pros and cons. So we have to be careful about the topics, about the costs, about the cultures, and who the disputing parties are. So that's my way of, I think, answering that question in a long-winded way.
I think you've answered one of the other Q&A questions about the role for mediation. And I would ask Lucien to have a look at the other remaining question, while Viva can tell us a little bit about her study and if she's planning to update it, or what the plans are in general.
So yes, I would like to update it because I think, as you mentioned, Laura, I think the study has been helpful. Unfortunately, it doesn't have this, it's smaller numbers. I think the numbers could be updated. There's not as much diversity. So for example, in the first survey in 2019, the respondents were all from kind of, Europe, they're from Latin America, they're from North America. I would like to see more respondents from Asia and from Africa, right? I think in order to, we had Brazil, but yes, sorry, correct. So I think, one is just updating the people who are responding and the types of disputes that are being resolved. And I think, the goal is to update that and to work with people around the world to be able to do it. I think it is helpful because it is an opportunity for us to now lay down the kind of infrastructure. As this field develops further in the future, I think we will need to know how the law has evolved in these commercial relationships or in these investor-state relationships or state-to-state relationships. So I think it's important. I would like to improve on the surveys, which I think were fairly generic, but thankful. I mean, I'm glad that people have found them helpful. I don't think they're surprising to a lot of people who've worked in this area, like, Rolf and Lucien, who've actually probably, been in this area for too long. But for people who are entering the field, I think it's interesting to see kind of how this area has evolved. So I think there's more to be done on that front.
I completely agree. Lucien, do you want to answer the Q&A?
Yes, very, very shortly. The first question is relating to mediation. I just want to remind you the fact that, for example, in the ICC regulation, there is a mediation procedure. And let us suppose that the arbitration clause refers to ICC regulation, the arbitration regulation of the ICC. You could get access to the mediation procedure. And usually when I draft an arbitration clause in a commercial agreement, I mention mediation, which could become in the next coming years a way of settling very quickly disputes. The second question is relating to a case between a manufacturer and its customer. And this case is relating to a situation in which the ITU asks to the customer of the satellite manufacturer to mitigate interference or stop satellite. Could we get any action against the manufacturer? Yes, depends on the commercial agreement you have with him. I will say that if you have an arbitration clause, that could work. And I will see very, very clearly that you could get access to the arbitration procedure and try to solve a problem, because the manufacturer, we have to keep in mind the fact that the manufacturer is not the only party in this chain. Keep in mind the fact that a satellite has to be launched, and the launcher could be the responsible of this misleading. And I'm quite sure that one more time, a quick look on your contract could be very advisable, and we will see, depending on the situation, whether you could get access to arbitration or you have to take an action before a judicial court. And if I ask a manufacturer company to build a satellite for me, and during coordination process, one of the coordinating country asks for specific filter, it is recommended to protect out of band, and manufacturer company refuse to add them. It's a long question, and asked me to pay the cost.
I think, Lucien, I think we're running out of time, and I think
excuse me.
Okay. No. It's sorry, but it's, I think it's too complicated to answer in 2 or 3 phrases, and I think we will address those questions at our next event.
Super.
So I want to thank all of you for a very interesting discussion this morning, and for sharing your very specific experience with the audience and with me. So thank you very much for accepting our invitation. Thank you again to Thorsten and Elena, and I will hand the microphone over to Elena for her closing remarks, and I hope we will stay in touch. Thank you very, very much.